Armenia's Hate Speech Blind Spot. Article by Anush Begoyan. Published on December 16, 2025, on EVN Report. When public speech tests its own limits. The boundaries of acceptable public speech in Armenia are being tested almost daily. Political talk shows, podcasts, street interviews, and social media discussions frequently slide from criticism into personal attacks, insults, and explicit threats. This trend reflects more than a decline in civility. It stems from a deeply polarized political environment, unresolved trauma from the 2020 Nagorno-Karabakh War, and a public sphere where emotion often overwhelms reason. Conversations about security, identity, governance, and accountability can quickly shift from debate to confrontation. It is against this volatile backdrop that the recent arrests of two well-known opposition podcasters reignited a larger national debate. Where is the threshold between harsh criticism and criminal conduct? When does offensive or vulgar language stop being protected expression and become a matter for law enforcement? And what principles should guide such distinctions in a democratic society? On November 13, 2025, law enforcement officers detained podcasters Narek Samsonyan and Vazgen Sagatelian, hosts of the Iem Namni Me program, after a live broadcast in which they used harsh language and reportedly issued verbal threats toward the Speaker of Parliament, Alan Simonian. According to public reports, masked officers searched their homes, seized equipment, and initiated criminal proceedings for hooliganism. The authorities defended the arrests by arguing that the podcasters crossed a legal boundary. Their speech, they claimed, exceeded criticism or insult and entered the realm of criminal behavior. As of this writing, no convictions have been reported, and the investigation remains pending. However, this incident reveals far more than an isolated case of controversial speech. It exposes a deeper normative and legal vacuum in Armenia's approach to regulating public discourse. At a moment when dissent, satire, and critical commentary are essential to democratic life, the threshold for criminalizing speech appears to be shifting in ways that are neither transparent nor principled. Free expression versus abusive speech. Armenia's legal dilemma. Armenia's struggle to regulate offensive speech is not new. In 2021, the government introduced a criminal offense of grave insult, presented as a necessary response to what officials described as the deteriorating tone of public debate. In practice, however, the law quickly revealed structural flaws. It was applied overwhelmingly against journalists, activists, opposition figures, and ordinary citizens who had criticized public officials. Within months, more than 260 cases had reportedly been initiated, and by April 2022, the Prosecutor General reported 802 criminal proceedings under the provision. Rather than protecting public dignity, the law became a mechanism for shielding those in power from scrutiny. Across Europe, similar honor-based insult laws remain contentious. Germany's Beleidigung offense continues to criminalize insult, with enhanced penalties when public officials are involved. German Criminal Code, Section 185. France's 1881 press law still treats public insult, injure publique, as a criminal matter. French Press Law, 1881. Even the United Kingdom maintains public order provisions that restrict abusive speech likely to cause distress. UK Public Order Act. Armenian civil society organizations warned of these risks immediately after the law's adoption. In a joint statement, the Freedom of Information Center of Armenia and other NGOs argued that criminalizing insult is a direct threat to freedom of expression and contradicts democratic principles. Public officials must be prepared to face sharp criticism without resorting to punitive measures. International standards echo these concerns. The OSCE representative on freedom of the media has repeatedly held that criminal insult laws are incompatible with democratic free expression norms and prone to political misuse. Article 19 has long advocated for the repeal of criminal insult provisions and the use of proportionate civil remedies instead. The Venice Commission emphasizes that public officials must tolerate a higher degree of criticism and that criminal sanctions for expression should be reserved for the most exceptional circumstances. Facing mounting criticism, Armenia repealed the grave insult offense in 2022. Yet neither its adoption nor its withdrawal solved the underlying problem. Armenia still lacks a principled framework for distinguishing between crude but protected expression and harmful, threatening speech. Why Armenian profanity often goes beyond mere insult. Linguistic and cultural specificities. A major flaw in Armenia's current speech framework is its assumption that all insults operate at the same level. In reality, Armenian profanity is linguistically and culturally distinct. Many of the most common profanities are explicitly sexualized, often evoking domination, coercion, or sexual violence. Crucially, these expressions are frequently directed not at the male addressee himself, but at female members of his family, invoking humiliation through sexual imagery. What appears to an outside observer as just swearing, thus, carries a threatening, gendered undertone. Language designed not simply to offend, but to degrade. When deployed in public or online, these expressions cannot be categorized as mere public insult. They function as gender-based, sexually targeted aggression. The harm is not only individual, but structural. These expressions serve to intimidate, exclude, and silence women and other targeted groups, thereby shrinking democratic space. This approach is consistent with international human rights doctrine. The Council of Europe's recommendation on combating sexist hate speech emphasizes that sexually degrading expressions constitute a form of violence against women, creating a climate of intimidation, hostility, and humiliation that undermines women's participation in public life. The European Court of Human Rights reinforced this logic in Bezaras and Levikas v. Lithuania, 2020, finding that authorities' failure to investigate sexually explicit, derogatory threats violated Articles 8 and 14 of the Convention, because such expressions represent gender-based violence, requiring a state response. These principles are especially relevant for Armenia. According to a 2024 Council of Europe report, 78% of interviewed high-level female public figures in Armenia reported experiencing constant gendered online hatred. 98% had experienced at least one form of cyber attack because of their gender. And critically, 68% reported they had at least once considered leaving public life as a result. Several women shared anonymized accounts of sexualized smear campaigns, such as the non-consensual dissemination of private images or threats to distribute fabricated sexual videos, that led them to limit or withdraw from online engagement. Local civil society echoes these findings. The All for Equal Rights Foundation reports that women in politics, business, and public administration face disproportionate online abuse, producing a clear chilling effect that deters them from participating in public life or expressing their opinions. Research conducted under the European Partnership for Democracy's 2024 program similarly documents that online hate speech targeting Armenian women politicians has become pervasive and limits their participation in politics and public debate. Women journalists experience comparable pressures. Human rights defender Zahruhi Hovannishian noted publicly that female journalists, especially those covering gender issues, are singled out for sexist harassment and online intimidation, with little meaningful institutional response, which affects their ability to work safely. These patterns illustrate that Armenian sexualized insults are not simply impolite cultural artifacts. They align closely with what international institutions recognize as sexist hate speech, a discriminatory practice that excludes women from public debate and undermines democratic participation. Given this linguistic, cultural, and democratic reality, it is insufficient for Armenian law to treat all offensive expressions under the same insult framework. Any rights-based approach must distinguish between ordinary vulgarity and sexualized, gender-targeted abuse that constitutes hate speech or gender-based violence. Toward a coherent, rights-based legal framework. The repeal of Armenia's grave insult provision, addressed only the most visible symptom of a broader structural problem. Armenia still lacks a legal architecture capable of recognizing and responding to the specific harm posed by gendered and sexualized abuse in public discourse. In a linguistic environment where sexualized threats are embedded in everyday profanity, a generic insult framework is both analytically inadequate and normatively misleading. International and domestic analyses consistently highlight these gaps. A 2020 Council of Europe comparative study concluded that Armenia's hate speech framework lacks clear definitions, fails to cover protected characteristics comprehensively, and gives practitioners insufficient tools to address discriminatory expression. The 2023 ECRI report on Armenia similarly urged authorities to strengthen monitoring and responses to hate speech, with particular attention to online abuse and closer cooperation with civil society. The Council of Europe's 2024 report on the digital dimension of violence against women in Armenia documented widespread sexual harassment of women in public life, noting that existing Armenian legislation fails to capture or address this pattern adequately. Local organizations reached the same conclusion. The European Partnership for Democracy found that online hate speech against Armenian women, especially politicians, has intensified and directly limits their participation in public discourse. Shadow reports filed to the CEDAW Committee and submissions by Pink Armenia have repeatedly noted that Armenian criminal law does not treat gender-based hatred as an aggravating factor, leaving victims with limited options for redress. Within this broader context, the type of sexualized verbal aggression that circulates widely in Armenia, especially when its purpose or effect is to intimidate or silence women, cannot be dismissed as a byproduct of polarized politics. It is a form of discriminatory harm that international norms classify as sexist hate speech. A modern, rights-based framework must therefore move beyond blunt criminal insult models and instead recognize gender-based and sexualized verbal abuse as a distinct category of harm, include proportionate criminal or civil sanctions for serious cases, ensure that threats or sexualized intimidation are investigated and prosecuted, protect women and other targeted groups so that they can participate safely and equally in public life. Such a framework would not suppress legitimate political criticism. It would safeguard the preconditions for democratic participation by ensuring that disagreement is possible without degradation and engagement without fear. Ultimately, Armenia must decide whether it is prepared to tolerate a public sphere in which some voices, particularly women's, are pushed to the margins by calculated sexualized hostility. If the answer is no, then its laws must reflect that conviction.